Hello, and welcome to a brief discussion about certified mail, return receipt, the new electronic options available from the Postal Service for certified mail, and legal implications and questions that you may have about it. My name is Doug Morrow. I am a retired USPS executive. I retired in 2009 as the district manager of Hawkeye District, which covers the state of Iowa and a portion of Illinois. In retirement, I keep busy with a number of things, including acting as postal automation specialist and general manager for Kringle Tech, as well as industry co-chair for South Central Minnesota Postal Customers Council, the PCC. You know, you can take the boy out of the post office, but you can't necessarily take the post office out of the boy. We're going to talk about certified mail, and what you're looking at is the PS Form 3811. Which since 1955 has really been known as the green card. Now that is not a postal term. That is just a term that the public uses. It is actually the PS Form 3811. The Postal Service would call it Return Receipt Service. Rules governing court systems around the country were written to validate that return receipt is proof of mailing and delivery. Some of that language that was written actually used the term green card, not the postal term, rather than return receipt. And that is where some of the problems have come when people have asked the question, is this legal? Because of that confusion between the word green card and the Postal Service return receipt service. So we're going to get into that a little bit. With the old-fashioned way, you would get the green card back. You would manually put it on the back of the card. You'd fill it out when the postal carrier delivered it or the clerk delivered it. They would get a signature. They would rip it off the mail piece and put it back in the mail, and you'd get it back in a week or so, and then you'd have to file it. With electronic return receipt, you get a PDF file that has an image of the signature. That's the only difference between the two. They both have signature. They are both proof of delivery, and the signature is valid. With e-certify, we take all the labor-intensive and error-prone processes out of certified mail. We don't manually fill out that 3800, that's the green and white slip that gets filled out, and then it gets pasted or glued on to the envelope so that that certified mail label shows up and the barcode's there. It's what gets the round stamp from the clerk at the post office that says, yes indeed, we received this piece. And then you actually fill out that 3811, which is the green card, and you tape it or attach it to the back of the mail piece. That's what gets pulled off and signed and sent back to you. That's the labor-intensive old-fashioned way. With e-certify, all of this is done electronically. Not only do you get the proof of mailing, proof of receipt, but you also get tracking of the mail piece along the way. Now the question comes up, is electronic return receipt considered legal proof of delivery? And frequently when you're trying to sell this product, and this question comes up, the question that comes up is, well, does the post office give you something, some document that says electronic return receipt is legal proof of delivery? So I'm going to try to answer that question because indeed the Postal Service does provide that. The government provides that, but not in the form of a letter or some kind of a document. The Postal Service is part of the federal government. And the federal government has many rules and regulations that are enacted by laws and bills and policies that are put out by various departments and agencies of the federal government. All of these rules and regulations are published in the Code of Federal Regulations, the CFR. And the Code of Regulations is the codification of the general and permanent rules published in the Federal Register by the departments and agencies of the federal government. And each one of these departments has different ways of including it in the Federal Register and in the CFR. Now, the CFR has stated that as far as the Postal Service is concerned, anything that is published in the Domestic Mail Manual is part of the CFR. In conformity with that provision, the U.S. Postal Service hereby incorporates, by reference in this part, the mailing standards of the United States Postal Service, the Domestic Mail Manual. So anything that's published in the Domestic Mail Manual is part of the Code of Federal Regulations. So, in effect, that is exactly what the Postal Service provides you, is proof that it is legal, because if it's included in the DMM, it's part of the CFR, which is the codification of the rules and regulations of all departments and agencies of the federal government. Now, in the DMM, this is the table of contents. Obviously, we're going to talk about what's legal and what's part of the code for letters, flats, cards, commercial mail, commercial flats, commercial parcels, and additional mailing services, which is what certified mail-in is. Now, the very first page of the DMM states that the Domestic Mail Manual provides the United States Postal Service official policies and standards for all domestic mailing services. It is what is part of the CFR. And within the DMM, it very specifically states that when it comes to return receipt, we're talking about return receipt service. And return receipt service provides a mailer with evidence of delivery to whom the mail was delivered and date. It also provides information about the recipient's actual delivery address. And it also states that a mailer purchasing a return receipt at the time of mailing may choose to receive the return receipt in two forms, either by mail, the Form 3811, or electronically by email. So clearly, as the DMM states, return receipt service provides evidence of delivery and information, and when you purchase return receipt service, you may choose to receive the information in one of two formats, either mail, which is the old green card, or electronically. Now, in the Pub 370, which is a marketing tool of the USPS, and this is how the USPS markets return receipt. It takes the words right out of the DMM, which is part of the CFR. A return receipt provides evidence of delivery. You also receive the delivery address if it's different from the address on the mail piece. For domestic mail, you may choose to receive the return receipt by mail with an original signature, or electronically a copy signature. Now, there are many court systems within the United States that actually use return receipt, and you may be familiar with Franklin County. Franklin County not only utilizes the return receipt, but goes to a great extent about how beneficial electronic return receipt is, and the fact that this is the form of proof of delivery and proof of receipt that the Franklin County Probate Court uses. It also talks about the fact that it is very cost effective and saves the taxpayers a great deal of money. Now, that particular system is actually a Neopost system, and it's part of the Document Solutions case study that Neopost uses. The Supreme Court of Ohio actually published a list of all the courts in Ohio that do use electronic return receipt and what systems they use for accomplishing electronic return receipt. Now, there has been cases where things have gone to court and a judge has said, no, you didn't use a green card, so it's not legal. And I want to talk about one of those just as an example of why this becomes a little confusing. Now, this happens to be, I believe it's a lien against somebody who didn't pay their storage for a storage facility. And the judge ruled that the notice sent by the storage company did not comply with the statutory requirements. The notice was sent by certified mail, but not certified mail return receipt requested, which is the old-fashioned green card. Now, after this decision, the company said, we're going to do a little research into this, and they petitioned the court to reconsider after they did some research. Manhattan conducted an investigation that electronic return receipt, which is what they used rather than the hard copy, 3811, that the electronic return receipt is the functional equivalent of paper return receipt, and that the recipient actually did retrieve her lien notice, and they had proof of it, electronic proof. In part of the dissertation to have this reconsidered, the verbiage is pretty good, and it's something that you could probably use if you ever need to. The Postal Service and the Domestic Mail Manual, which provides the regulatory details of all domestic mailing, and as I talked about is part of the CFR, treat the traditional paper green card and electronic versions of return receipt as legally equivalent. The New York law does not define these terms. They are only defined by the USPS and the federal regulation as published in the Code of Federal Regulations. The judge went by his interpretation of green card. I need a green card. That's what return receipt is. Now, the actual code that the judge should have used to make that decision doesn't say green card. It says return receipt. So the judge is interpreting using the word return receipt synonymous with green card and assuming that I need a green card. There are many states who realize that this is a problem, that the codes that they have written for judges to use are out of date, and so they have gone in some states to actually change the code. This is part of a petition to change the rules that Pennsylvania uses, for instance, realizing that the post office has offered electronic returns receipts for certified mail in lieu of the traditional green cards, so they are petitioning for a change of verbiage in that code, and this is the actual change. Nothing in this rule is intended to preclude a judicial district from utilizing the USPS's return receipt electronic option or any similar service that electronically provides a return receipt when using certified mail receipt requested. West Virginia actually changed the words to include electronic return receipts. Now, some states have done that, some states have not. But we're going to talk about whether they have or have not. There is a law that is out there that has been adopted by many states that really fulfills our need to be able to prove that this indeed is legal. This is from the state of South Carolina, where there was a question with the DMV. They wanted to use electronic return receipts, and they needed some kind of ruling that indeed the courts would recognize that as legal, because obviously they could save a great deal of money. Part of their verbiage is, you note that the United States Postal Service has approved electronic return receipts provided by this private company and other vendors. Basically, the recipient's signature is collected and stored digitally, so unlike typical green cards, it cannot be lost. The sender may then print the digital receipt when needed, or download the delivery date into a spreadsheet or data file. So that was the request to the Office of the Attorney General, and the Office of the Attorney General used the UETA, the Uniform Electronic Transaction Act, to respond and to make a ruling. And what it talks about is that the UETA provides that electronic records and electronic signatures meet writing, signing, or original requirements in the South Carolina laws without having to amend existing laws or regulations. goes on to explain that the UETA provides a record or signature must not be denied legal effect or enforceability solely because it is in electronic form. A contract must not be denied legal effect or enforceability solely because an electronic record is used in its formation. An electronic record satisfies a law requiring a record to be in writing, and an electronic signature satisfies a law requiring a signature. And then in his conclusion about whether this would be legal or not, Robert D. Cook, the Deputy Attorney General, and the Senior Assistant Attorney General, Mark Rappaport, talk about, however, it is the opinion of this office that service under consideration by the DMV, which generates a detailed report of an electronic signature designating acceptance of receipt, would likely be considered by a court as adequate evidence of delivery of statutory notice of suspension or service of process, as are the inked signed copies of the green card. If a law requires that a record of signature be retained, we believe the requirement is satisfied by retaining the electronic form of the signature as a record by the government entity. To hold otherwise, simply because technological advances have allowed for electronic records and signatures, would run afoul of the expressed intent of our legislature in enacting the UETA. So let's talk a little bit about what UETA Act is. Too many letters. The Uniform Electronic Transactions Act, UETA, was developed by the National Conference of Commissioners on Uniform State Laws to provide a legal framework for the use of electronic signatures and records in government or business transactions. UETA makes electronic records and signatures as legal as paper and manually signed signatures. 47 states have adopted UETA. 3 states have not adopted UETA, but as I've shown you some examples, they each have statutes pertaining to electronic transactions. So the question is electronic return receipt considered legal proof of delivery like the green card? Well, absolutely yes. Return receipt is information received in one of 2 formats, per the CFR, the DMM, UETA, and local statutes. And no, if a judge chooses not to accept it. And so my answer for you is absolutely it's legal. It's part of the Code of Federal Records. This is published in the DMM as legal, and you have 2 forms to receive that information. That doesn't mean that you're not going to run into somebody who